Charged week of high-profile trials with the combination of the men charged with murdering Ahmaud Arbery being convicted and, of course, Kyle Rittenhouse being acquitted. The interesting thing, and Andy McCarthy writes about this in a piece in National Review, is that the Arbery case, if you just read the media's coverage of it, you would think it was solely about race, 3 white guys killing a black guy. Well, that wasn't the case the prosecution put on at all. So even a case like the Arbery case, the media gets it largely wrong and has to use that as an opportunity to try to infuse our culture with more racial polarization rather than good sense and an understanding of the law. For more on this, we're pleased to be joined by the aforesaid Andy McCarthy, former chief U.S. attorney in Manhattan, contributing editor of Wall Street Journal, contributing editor to National Review, that is, where he posted the piece on Arbery I mentioned, and also author of the bestseller Ball of Collusion. Andy, thanks for joining us. Appreciate it.
Morning. Happy week.
Yes, good to have you. This is an important point that you zeroed in on at breaking down the charges for which each of the 3 individuals were convicted, and showing sort of how the jury really took pains to assess each of the 3 individuals under the law and offer their renderings based on what each individual's role was in the murder of Arbery and what the charges were correspondingly. But that whole emphasis on race, that was the coverage of the trial, and it wasn't the case that the prosecution presented. Develop that for us.
Yeah, and it's worse than that, Dan, because it's the predicate for the there's a Freudian slip, the Biden Justice Department civil rights case against the same 3 defendants. So the oddity to me, and this goes right to your point about sowing and exacerbating racial divisions that they stoke up and use to do that very thing. The whole point of the Biden Justice Department's prosecution of these same 3 individuals is that Arbery was essentially killed because of his race. And my point is, if that were true, how on earth could the prosecutor in Georgia have proved it without infusing race into the case? So what they proved beyond a reasonable doubt in the Georgia case is that Arbery was killed by these guys who made a terrible mistake of law, in the sense that they thought that they had probable cause to make a citizen's arrest of him. Now, I think it's very clear from the evidence that they were woefully short of probable cause, but that doesn't mean they didn't have any reason to suspect him. There was evidence that came into the record that Arbery was on this property that he didn't have any reason to be on. They didn't have any evidence that he actually stole anything, but they did have evidence that things were stolen from that site, and he was there under circumstances repeatedly filmed there under circumstances where he had no reason to be there, and they suspected that he was at least one of the people who was stealing stuff from there.
Well,
now,
but other people were filmed. I mean, I looked at that surveillance tape too, and there's a lot of other people from the neighborhood that would walk through those properties that were under construction. Why didn't they chase after them?
Well, I don't think they saw them that day, Amy, but they did know that the police had been showing photographs of Arbery.
Okay.
And I'm not, don't get me wrong here, I'm not saying that there aren't racial attitudes here. I don't know if there are or there aren't. There may be. But the evidence in the case is that they suspected this guy of being a thief, and they had insufficient evidence for that. And as a result, it was excessive force for them, since they didn't have a right to make an arrest in the first place. It was assault for them to chase the guy. And obviously they didn't even have a basis to use force, and they used lethal force. So they were properly convicted of murder. But all I'm saying is the Justice Department's theory, and what the media is trying to sell the country, is that these 3 guys were out hunting down black guys because it was, it was Sunday afternoon, so it's time to go out and shoot a black guy. And that's really not what happened. They actually did suspect this guy.
Well, and in addition to that, if there was evidence to support the racial component, then the prosecutor ostensibly would have presented it because there's nothing but upside to present it, right? That provides the motive for why potentially, if there was evidence to support it, provides the motive for why they exceeded the authority they had under the law.
Yeah, I think that's the big point to me, Dan, is I was reacting mainly to a story in the New York Times where they basically acknowledged that the prosecutor didn't turn it into a racial case and made up some cockamamie thing about how it might have been offensive to the jury to do that. And I can tell you, having been a prosecutor for 20 years, if you have motive evidence, and here, understand, in most cases you don't have to prove motive beyond a reasonable doubt because it's not what they call an element of the offense. So you're allowed to prove it because it's relevant to showing intent, but you don't have to prove it, and it's not an element in the offense. In a federal civil rights prosecution, it is an element of the offense that you have to prove beyond a reasonable doubt. So the Biden Justice Department would have to prove that Arbery was killed because of his race beyond a reasonable doubt, that was the reason that they went after him. So what the Biden administration is saying is, in this case, the proof of racism is so powerful we can prove it beyond a reasonable doubt. And you're telling me that Georgia prosecutor didn't use it?
Right.
When you have motive evidence that's powerful motive evidence in a murder prosecution, you use it.
No, you know what they're going to argue? They're going to say this, and the New York Times will report. They say, "Well, this is evidence of systemic racism. They didn't use race because they were afraid that it would have got these guys acquitted, but they still got 3 guys convicted of the murder of Arbery, and that's still, no matter, even that is still evidence of systemic racism in the system."
Yeah, well, that's because that's what they're down to, and that's what I think the Biden civil rights prosecution will be about. You know, they can't prove, because if they could, the Georgia prosecutor would have done it. They can't prove that these guys had such deep racial animus that they would go out and kill somebody. But what they're going to say is that the inherent racism in America, even if undetected day to day, is so insidious that that really the people who were involved, who are charged as defendants, they're really just sort of the pointy end of the spear. But let's face it, we all killed Ahmaud Arbery because we're all racist.
Right.
I mean, that's what the pitch is.
Right.
Let's move. Can we move over to Waukesha and what happened there, and about this bail charade that needs to be ended?
Yeah. Well, I really think this whole idea of what the progressive prosecutors say is that cash bail is essentially another tool of racism because it criminalizes poverty. Only the rich people are able to make bail, and the poor people have to sit and rot in jail. So it's a ridiculous narrative because the number of people who are in jail because they don't get bail is a function of people's offense patterns. And if a group offends at higher rates, then they're going to be denied bail on higher rates, and they're going to be, post-trial convicts at higher rates. But we are playing into the progressive narrative by having this idiotic system where that somebody like this guy who committed this awful mass murder attack in Waukesha, we all should say he's a danger to the community. He shouldn't get out on bail. But in Wisconsin, like in many states, they don't have a provision that allows a court to deny bail. So you have to set bail. And what that ends up meaning is you set it at such a high rate that explicitly, in this case, they said, we need to set it so high he can't meet it. And in the meantime, the purpose of bail is to allow somebody to be at liberty while the trial, while you're awaiting trial and standing trial. And what the Constitution says is that excessive bail is prohibited, which means you don't have to set bail in every case, but where you do set it, it has to be makeable bail. It's got to be reasonable. So what I'm suggesting is that the states adopt the federal standard, and I recoil from that kind of a requirement. But the fact is that the Congress has been dealing with the Eighth Amendment longer than the states have, and they've passed legislation in the 1980s with respect to it that the Supreme Court has basically said was fine constitutionally. And what it allows the court to do is deny bail if somebody is shown by the prosecutors to be a danger to the community, which can mean the community at large or to specific people in it, like witnesses, for example. So the court can just deny bail. So it's not a situation where anybody can say bail was denied because of your race or bail was denied because you were too poor to make bail. It has to be the prosecutor can prove that, at a certain quantum of evidence, in federal court it's clear and convincing evidence, that you are such a danger to the community that you can't be on release prior to trial. And then we get rid of this whole charade where, you set bail at $5 million like they did for this guy Brooks in Waukesha because they think that's the amount he can't make.
Well, and then the flip side, though, even without adopting the federal standard is, there's just sort of the common sense standard of this guy is a habitual criminal, and for him to be given $1,000 bail the weekend before he committed this atrocity, this mass murder, be $1,000 bail for trying to run his baby mama over with a car with a criminal history he has. What is a prosecutor thinking?
Well, what they're thinking is, this particular guy, a progressive prosecutor, their principle, if you can call it that,
yeah, right,
is that nobody should be in jail in the first place, but nobody should be denied bail. Everybody should be out while we even decide whether we should prosecute. Most of the time they don't want to prosecute; they want to divert. And you can't say that this guy didn't think of it, because in 2007, this is the prosecutor John Chisholm in Milwaukee.
Right.
He explicitly said in an interview, look, is someone that I divert or release going to go out and commit murder on release? Sure, that's going to happen. But even though that's guaranteed to happen, it's still worth pushing through these reforms. So I suppose that sounds great to progressives on the campaign trail. But the problem is that these nostrums end up colliding with real life. And the result of it is what you see in Waukesha, a guy who has no business being out on bail, who was let out not one, but two cases in Milwaukee at a time when there was a pending sex offender warrant out before him from Nevada, is turned back out on the street and commits a mass murder attack.
It's one of the things I think people have a hard time believing, that these prosecutors like Chisholm, like Fox, like Krasner, like Bowden, they are ideologues, and that their ideology takes precedence over the rule of law or public safety. But people just have a hard time actually accepting that's the case.
Yeah, I think that's right. But the other thing we have to bear in mind here is every single one of these guys that you just mentioned, Dan, they're all elected.
Yeah.
The people elected these people.
Yeah.
So, sometimes you get what you vote for, and
we know what that's like in Chicago.
Good and hard, as H.L. Mencken used to say. That's right. Andy McCarthy,
right.
former chief assistant U.S. attorney in Manhattan, contributing editor National Review, author of the bestseller Ball of Collusion, The Plot to Rig an Election and Destroy a Presidency. Andy, thanks as always. Appreciate it.
Have a great week. Thank you.
Yeah, thank you. And he joined us on our turnkey.pro answer line.
You've made the switch, and it feels so good. You switched to Chicago's Morning Answer on AM 560. The Answer.
Amy Jacobson and Dan Proft here, and we want to tell you about our 2021 Food for the Poor campaign, and this year is like no other.
Food for the Poor is a nonprofit, faith-based organization that provides food, water, medicine, clothing, and life-saving supplies directly to local organizations in Haiti.
Haiti has been devastated by poverty, disease, civil unrest, and natural disasters like the earthquake that struck in August, which has left millions of people without regular access to food.
Food insecurity hits children and their families particularly hard, which is why the work that Food for the Poor does is so important. Literally, the only thing between these children and their families and starvation is food for